Welcome to Divorce Coalition Live, a show designed for divorce professionals about how the divorce process affects domestic abuse survivors. So we look at it from the point of what can we do to make sure that abuse survivors are not re-traumatized by the divorce process and professionals involved. I'm your host, Beverly Price, Executive Director and CEO of the Divorce Coalition and certified divorce coach at Coaching by Beverly Price and Her Empowered Divorce. The Divorce Coalition is a nonprofit organization dedicated to increasing the education and awareness of divorce professionals to create a more supportive and less traumatic divorce experience. We have united top podcast hosts and divorce professionals to create systematic change in divorce for domestic abuse victims. With expert guests, practical advice, and enlightening conversations, you'll find that knowledge is power in creating change in the world of domestic abuse. So without further ado, let's get started. In today's world of divorce, there is so much to learn. There are so many people that have experience, and there's so many people that are starting out. So, one of the questions we want to know the answer to is, if we're divorce professionals, what do we know about the court process? There are so many aspects, whether it's family court or whether it's criminal court. And I've got a fantastic guest for you today, Larry Jones, who is a former judge, who is going to enlighten us on his perspective on many of the top issues of divorce and domestic abuse. Hi, Larry. How you doing? I'm so glad to have you back.
I'm doing great, Beverly. It's great to see you again, and thank you again for having me here with your audience.
Absolutely. Can you tell the audience just a little bit about yourself and your background and your passion about
Sure.
this topic?
Sure. I was a family court judge for many years in New Jersey, in the Superior Court, a family court in New Jersey. And among my duties were presiding over domestic violence cases. Before I was a judge, I was a practicing attorney for many years in the state of New Jersey and represented many people in domestic violence proceedings and in divorce proceedings and other types of family court proceedings. After retiring from public service in 2017, I've taught at several universities, and we developed a whole program on domestic violence law and policy at Monmouth University. And now I live out with my family in New Mexico, and I'm teaching at the University of New Mexico. And I'm involved in various domestic violence related projects here in New Mexico as well. So it's a pleasure being here again with you today, Beverly.
There are so many questions I'd love to ask you, but one of the ones that comes up very frequently is, what is the effect of restraining orders on custody support, asset distribution, and what is kind of the restraining order environment for domestic abuse survivors?
Okay, that's a very, very broad question. So let's kind of break it down a little bit. Well, first of all, as with any area of the law, it's always important to know whether you're, especially if you're representing yourself, but even if you have an attorney, to really know what the law is on the subject matter that you're in court about in your state, because you have 50 states, and the laws can be very different on a state-by-state basis on the same
Right.
subject. So, for example, with domestic violence and domestic violence courts, each state tends to have its own set of statutes and set of procedures. A lot of them are similar, but they're not all the same. There's no one size fits all, a uniform way of conducting domestic violence proceedings and what the impact may be of a domestic violence restraining order on some of the issues, Beverly, that you just referenced, custody or parenting time or support or asset distribution, things like that. It can vary very much from state to state. And within the state, there could be sometimes some ambiguity in the prior case law and things like that in terms of what, if any, impact the domestic violence restraining order may have in a certain situation. So these cases tend to be extremely fact sensitive without an overall generic, this is the law for all 50 states type approach.
Mm-hmm. Amazing. That's just so. And then you have the aspect, I think, of the perception that a number of abuse survivors report their spouse who goes to jail or get a restraining order, and then they kind of change their mind. Can you elaborate anything on that?
Sure. Well, that happens an awful lot. I would see this very frequently when I was a domestic violence judge, that somebody would come in and they would seek initially a temporary restraining order. And then by the time it got to a final hearing, either they wanted to withdraw it, even though it was only a few days later, or they would proceed with the final restraining order. They would get a final restraining order. Sometimes they would have a hearing that took a whole day or sometimes longer. And then I'd find out, 2 days later, the person who got the restraining order, the protection of the restraining order, was down in the court clerk's office seeking to dismiss the restraining order they just got. Sometimes they spend a lot of time and money and effort to get that restraining order. So that happens quite a bit. And in general, again, each jurisdiction may handle things differently. But in general, the concept with domestic violence is if somebody voluntarily wishes to dismiss the restraining order that's in place to protect them, that right should be respected and honored as long as they are making that request voluntarily. That becomes sometimes a judgment call because sometimes it's not so voluntary. Sometimes the evidence reflects that someone has been basically pressured into dropping the restraining order, either by direct contact with the person who was restrained in violation of the restraining order, or sometimes common family members or friends or that type of thing. Or sometimes children when they're old enough, let's say you have teenagers and they're saying, well, why don't you drop the restraining order against dad or mom, that kind of thing. So sometimes, people make a decision based on their own independent judgment. And sometimes it's a matter of they've been pressured. And so if the evidence reflects that there's some pressure going on, that the court could perhaps stay the request, put off the request to drop the restraining order, give the person a little more time to go speak with the counselor or go speak with an advocate and come back in a week or so. And then if they still want to drop it, and if the court finds that this is something they are doing independently and it's their own decision, in general, that should be respected.
Yeah. I think for many of my clients, what I see is kind of two reasons for that. One is they're fearful that there will be retaliation or a breaking of the restraining order by the abuser, or they feel like that abuser will change. And they are in love with the idea of who the abuser could be rather than who the abuser is.
Right.
So I've seen that going on as well.
Yeah, I mean, you see, there are all kinds of reasons people may choose to voluntarily seek a dismissal of a restraining order. Sometimes they really have the view, and they've reached this decision on their own, that the person has changed or will change. And, sometimes they might be right, and sometimes they might be wrong. And sometimes the person who is the abuser portrays themselves in a way that's very artificial.
Yes.
And it's very common. There's lots of studies on this, the cycle of domestic violence, and the Dr. Lenore Walker book going back to the early 80s, the Battered Women Syndrome, about the cycle. And when somebody commits domestic violence, they very often come back and indicate how remorseful they are. Sad, and they'll come with a dozen roses or whatever it may be and promise to be good forever. And so sometimes the person who was protected by the restraining order will go with that.
Right.
And because that's what they choose to do. And again, if that choice is voluntary, and that becomes a difficult question sometimes as to whether it's voluntary or not. But if the evidence reflects that it's voluntary, again, that they have the right, people have a right to seek a dismissal of a restraining order that was set up for their protection, just as they had the right to request it in the first place.
Do you think there's anything that divorce attorneys or attorneys in general handling cases such as this and restraining orders can do to reduce the instance of people retracting the restraining order that is in there for their own good, if that question makes any sense?
Well, look, every attorney, who represents the interests of any client, and we're talking about, in this instance, family court, on the one hand, you try to be as empathetic and understanding and basically as advisory as possible, because they're paying you or they've hired you to give them advice. But by the same token, you can't live someone else's life for them. There could be lots of attorneys out there who say, I don't think that this person should get back together with that person. I don't think they should do that. But, it's kind of presumptuous for anybody to start telling anyone else how to live their life, quite frankly. What you can do is educate the person. What you can do is help direct them to, you should go speak with a domestic violence counselor first, a resource center first, talk about other options besides getting back together. Because there are other options. It's not all or nothing sometimes. You could stay separated and still have a relationship with the children, that kind of thing, potentially. But other times, people just they just decide they want to go back with someone who they had a bad relationship with. And, when I was in practice, I had this came up several times, and very often what you'd see is the abuser, as part of the pattern of domestic violence, try to segregate the one who was abused from their family and friends and their
isolation.
And so, and also a lot of times people who commit domestic violence have tremendous egos. And it's like, they run everything, they want to run everything, that kind of thing. There's a lot, not every person who commits domestic violence is the same, but there's a lot of that commonality in the personality of those who are abusers. And so it's not uncommon to see a situation where somebody is promising, I'll be good, and they convince the person to take them back, and the person does take them back, but the first thing they do is they isolate that person from the rest of the family who was supportive of the person getting the restraining order in the first place. They become the enemy, and they convince or try to convince or persuade the person who got the restraining order that their family was the enemy. Their family was at fault because they think less of that, of the abuser, that type of thing. They're getting in the way. So I used to say sometimes to clients, I know you're hearing that, your ex might, is saying he's improved, etc. He's not going to do this anymore. He's apologizing 1,000 times over. But would he apologize to your family? Would he admit what he did to your family and what he put them through? Because if the answer is yes, before you drop that restraining order or as part of the process in court, then maybe the person is sincere, maybe. And some people do change. They do. There are people who do, who do change sometimes. You can't just say everybody's one way versus another way. These are all fact specific. But if they're refusing because of ego or otherwise to also make amends and apologize for what they did to your family on an extended basis, even though by hurting you, then it may be this person is not being genuine, is not being sincere, and is just focusing on you and what he has to tell you, because his goal is not to be a changed person, but to say or do whatever it takes to get you back, and basically make the rest of the family, who he has no interest in, perhaps, because in fact a negative interest in, because they're thinking less of you and causing a problem in their mind, in his mind, with the relationship, then that's potentially circumstantial evidence that you want to be really careful about just buying into the alleged sincerity of the reformed abuser. And so I brought this up a couple of times to some clients along the way, I recall, many years ago, and the person would not apologize to the family. And sometimes they drop the restraining order anyway. They just, well, that's the way it goes. And sometimes they say, well, I'm not going to drop this just yet. So it was very much an individual choice by each person. But it was helpful to some people along the way, and others didn't want to hear that. They just wanted to reconcile and go back to the life they were looking for in the first place, or potentially thinking they were going to get, even though the things like counseling, domestic violence counseling, batterers intervention, either anger management, things like that were not in place at all. They were just going in and dropping the restraining order and just kind of hoping that suddenly by magic, everything was going to be different. And it wasn't going to be different, because a lot of those times they were right back in court a month later with another domestic violence complaint and restraining order, thus the cycle of domestic violence.
Right.
So I think if attorneys just kind of, do what they can to provide options and not be overbearing with it, not try to control the client's life, but just advise, then it's obviously up to the client to make decisions as to what they want to do.
Absolutely. So you've got this situation where you've got a judge looking at a case. How can the survivor make sure that the judge understands their side of the case?
Okay. Well, it's really important to always understand that a judge's job is not to be an advocate for either side in any case. A judge by nature has to be neutral, has to be objective, because the whole process depends on both sides in any case, no matter what the allegations are, being treated fairly and equally in the whole process. That's part of our democracy and part of our judicial. So the judge, it can't be that the judge comes in and starts advocating for one side or the other, no matter, because then you have an unbalanced playing field. That could be an unfair process, right? So it's really, especially for lawyers, it's really important to, first of all, have a game plan in place in terms of how you're going to present the strengths of your case. So in a domestic violence case, by way of example, in most jurisdictions, they have a form for domestic violence, a domestic violence complaint form. It may differ in each state, but the elements of whatever a court needs to consider are usually in that complaint. Knowing the statutes and knowing the laws concerning domestic violence and what has to be proven becomes important. And it's very important to kind of break down the case into elements as part of preparation for a hearing, so that you're making things as easy as possible for a judge to understand each and every component of your presentation, and not to just come in and be all scattershot and disorganized and just saying all kinds of things, whatever, comes into your head. There has to be some organizational outline in place, because keep in mind that in domestic violence court in general, in my experience, judges tend to get, many cases per day. It's not like one case one day. It's very rare when you see that. And so things are moving kind of quickly, and things kind of blur together in any situation when you're throwing a lot of stuff at one person. Just the nature of the job. And so the clearer you make your presentation in a short period of time, in a concise period of time, the easier you make the job for the judge to follow along what you're talking about. So in domestic violence, what tends to be the main components of a domestic violence case is, number one, what is being claimed to be the predicate act between the parties? What is the main act that caused the person seeking the restraining order to get the restraining order?
Okay.
It's usually something specific. You want to focus, very heavily on that. That's the act in question. Number two, there's generally, with domestic violence, you have to put things in the historical context of the relationship between the parties. So if there is a prior history of domestic violence, it's not necessarily the predicate act, but things which took place leading up to the predicate act, you want to be prepared to testify about what those prior acts were and when they took place, and to concentrate on the most significant acts, not every little thing that may have happened during a long-term relationship or even a marriage. But if, for example, if somebody was hit previously, and not all domestic violence has to be physical, but if there is physical violence, that's certainly important to bring up in the history. And if there's non-physical violence, other types of harassment or threats or things like that, verbal type of stuff, to put that in there as well, but really to try to focus on what you think are the most significant past events which took place within a limited period of time, because a court's probably not going to have the time to let everybody going through every aspect of a many year or decade relationship in some cases. You got to kind of get down to the really brass tacks in terms of what were the main reasons why there's a history of domestic violence, or what were the actual incidents. And this becomes really important because some acts of domestic violence, some predicate acts, it's not so clear cut as to whether there should or should not be a restraining order granted. If somebody hits somebody, that's one thing, right? But if somebody makes a threat like saying, I could just kill you, something like that. They just say that. Now, somebody could say that in a lot of different contexts. If someone says that and they're just joking around, sometimes people say that and they don't really mean it's a threat.
Right.
On the other hand, if there is a history of threats to kill, or a history of violence or physical violence or other types of violence, then a verbal threat like that takes on a whole different meaning against the backdrop of past violence. So the past violence doesn't necessarily become the basis for the restraining order, but gives the context to adjudicate the predicate act to determine if, in fact, this is a dangerous situation that really warrants the issuance of a restraining order, rather than two people kind of joking around, that type of thing. So being organized in what the past history is becomes important. And then, also having your evidence in order. When I say having your evidence in order, in this day and age, a lot of people come into court, especially if they're not represented, and they're really not sure how a hearing works. So they have all their evidence on their cell phone, which has become basically like everyone's file cabinet in their pocket these days. You got everything on there. You got photographs, which might be relevant for domestic violence if there's bruising. You might have videos. It could be tapes of calls, somebody calling and cursing them out or threatening them, whatever it may be. And if you have all your stuff on your phone and it's not printed out or not in duplicate, now think about if you're going into court. How is the court supposed to take any of this evidence off of your phone? And even if they could sit there and have you play it for them or things like that, there's no record of it at that point. The other side doesn't have a chance to see it, which they're entitled to generally, just like you're entitled to see what the other side is producing. There's a restraining order in place, at least a temporary one. So you'd have to stop the proceedings to pass the cell phone around. What if something gets deleted? What if something gets damaged? It takes a lot of time. And remember, a court's dealing maybe with 30 other cases that day on domestic violence. So they don't have the time or the ability in most cases, I would suggest, to just stop the proceeding every time someone's looking on their cell phone, because they didn't take the time to print things out, perhaps in triplicate, a copy for the court, a copy for the other side, a copy for you, and be organized about it. And also, sometimes people, they go, I have a great tape. They need you to hear this tape. They're telling the court. And it's like a 2.5-hour tape, and they can't even find what part of the tape they're looking for. And in that 2.5 hours, you can't expect the court to sit there and listen. To 2.5 hours of tape, and half of it or most of it may not even relate to what you're talking about. It could be just a 20-second segment. So to at least, you can't start editing tapes and things like that are going to come into evidence, but at least have it marked for where it's going to be on the tape in terms of, timestamp, that type of thing. Have a transcript of it if possible available so the court could follow along. That transcript could be marked into evidence. It's just a matter of basically being prepared and being ready to present your case. That's almost as important as presenting the case itself. And there's so many people who treat domestic violence, including attorneys sometimes, who really don't come in prepared, because a lot of times domestic violence cases are considered like a summary hearing or an expedited hearing, and people just walk in and they're just kind of winging it. And I've seen people lose cases that way. So being, even though the proceeding may not take that long in some cases, the issue is critical. We're talking about domestic violence and a restraining order that can impact on so many aspects of life that you got to take the time to organize yourself and prepare for it. It's almost like a job interview in a way, that, you have the preparation could take far more time than the actual interview itself. But you're trying to, you're basically persuading or trying to persuade a court to see things your way and why.
So can you give a few specifics on what good preparation might be for an attorney in this case?
Yeah. Well, first of all, I think asking and trying to find out if there is any physical evidence, such as photographs, such as videos, such as audio tapes, such as texts, and finding out what they are, and then getting copies of them, getting organized, not on the day of the domestic violence proceeding in the hallway of the courthouse, but at least a couple of days beforehand. That's number one. So that there's an organization. You set up a 3-ring binder, whatever you have to do, and you're organized. When you walk in, you're not like rummaging through papers or playing around with your cell phone while, the court's got 50 other things to do, that type of thing. So that's number one.
Right.
Number two, if time permits, and I would suggest time should permit, if people plan their schedules correctly, is I think it's very helpful in an attorney-client relationship for the attorney to do a practice walkthrough of the
Yes.
proceeding. And to be kind of tough about it. What I mean by that is not just throw softball questions at the client, but also play the other side, what the cross-examination may be,
Yes.
so that your person's a little prepared. A lot of people, when they go for a restraining order, it's their first time in court. And you can't expect, no matter how smart they may be in their professional life or their personal life, everyone could be a little nervous when they walk into a brand new environment. You listen to people talk, former presidents of the United States, they say their first week in office, they were like overwhelmed. It's like, what am I doing here? That type of thing. And these are the leaders of the free world, So it's just human nature. And so going through a practice run of it, and the attorney should never tell the client what to say or try to put words in the client's mouth, but going through what some of the questions may be so that they're prepared a little bit is smart lawyering, is what that is. It's being a little prepared. And if the client has the opportunity and time permits to maybe go down to the court and watch a couple of the proceedings of other people, as long as it's not a closed proceeding, these things are generally open to the public. So to watch and to be familiar with it. I mean, I have seen people, when I was on the bench, I saw people when they got up to testify, very smart, intelligent, accomplished people, forget their names, forget their dates of birth, suddenly drawing blanks on everything, and then apologizing 6 times. They don't have to apologize, but it's that happens. But you can avoid it to some degree, or at least try to avoid it by being a little more prepared. And preparation takes work. It just flat out does. And it's not a matter of just walking in and telling your story, because everyone plans on doing that. And, there are rules of evidence. There are rules of civil procedure. There's a structure to these things. If it doesn't go your way and you need to appeal it, you want to make sure that that record is set up for an appeal. And they're all, and this is part of an attorney's job, is to set it up that way. Not, when I say set it up that way, is to be prepared, is what I mean. And to basically create a record that if it is going up on appeal, it's appropriate. The record's appropriate. You're not throwing things in on appeal for the first time, that type of thing, which could be problematic.
I think for a divorce attorney or an attorney in the situation, I've had a client that had the experience where the attorney called them on a Friday and wanted them to pull all of the documentation together for them by Monday.
Yeah.
And there's a couple of things that go on with that. And that is, for the victim to go through all of that is a little bit like reliving the experience.
Right.
And so to give them as much time to prepare and to give them as much direction on what to do, because I think you need to understand that that victim is fearful, is maybe not thinking as clearly as someone who is not a victim,
Right,
and how to handle that. And then I think as well to advise the client to focus on facts rather than emotions, because I think a lot of people want to go in and just tell their emotional story, but what you want to do is communicate so that you will be heard and get the result you want.
Well, it is important, first of all, the bit about calling on Friday and preparing them for Monday. Really, in any case, not just domestic violence cases, but if someone is going into court, unless it's an absolute emergent proceeding that can't be adjourned for a few days or whatever it may be, to call somebody on a Friday and say, this is everything we need for Monday, puts an awful lot of anxiety and stress and sometimes duress on the person receiving that information. Because all of a sudden, they're under enough pressure thinking about going to court. Now they got to scramble around and try to put things together. And you're right, it could cause further triggers as well, depending on what it is they're gathering.
Right.
And also some things take a little more time to gather. It's like if you're looking for anything in your house, you're looking for scissors or Scotch tape. It might take you a few hours to find it. No one knows where everything is at every minute. So sometimes it's helpful to at least speak, the attorney and client, to speak about the possibility of requesting a short adjournment. Now, a lot of people say, yeah, they just want to get it over with, and I'd rather go there unprepared and live with this another few days. But then you got to live with that decision.
Yeah.
And so there's nothing wrong with requesting adjournment sometimes. That doesn't mean you're automatically going to get them. But generally speaking, like I said before, domestic violence cases tend to be accelerated cases in most states. It's not like you're going to file a domestic violence complaint and have your hearing 5 years later. It's going to be, the next week or 2 weeks later or something really quick. And so by its very nature, you get these cases where people file a complaint and then they're in court, just, in a blink of the eye later. So it's not uncommon, especially with lawyers involved, for there to be requests of the court to adjourn for a short period of time the proceedings, so there's an opportunity for there to be preparation, not just preparation by the client, but by the attorney as well. The attorney may have 100 other cases going on. They need the time to focus and go, not only for you to gather the evidence, but think the example you just gave. All right, so now the client's gathering all this information. They get this call Friday. They're spending Saturday and Sunday gathering all this information for their Monday hearing. So when's the attorney supposed to review that stuff?
Exactly.
In the on their way to the court, so it's set up to fail, really, when you do it that way, when you have such a short string. Now, sometimes you get attorneys who could have given notice to their client, 7 days in advance, and then just didn't until 2 days in advance, and that's an error on the attorney's part, obviously, because you have to, especially on something like domestic violence court, you have to be on top of these things fairly on a fairly timely manner. But asking for an adjournment for a few days is not a bad thing. It may be granted, and if it's not granted, at least you tried, that type of thing. And by the way, even that could potentially be the basis for an appeal sometimes. If you made a reasonable request for an adjournment and the court said, no, we're not adjourning, and gave you one business day to set up your case, some appeals courts might say that was a little unreasonable in some cases, because everyone's entitled to some reasonable time to prepare their case. And then of course, if the person has been in domestic violence court before, because a lot of times you have a case where they've already been before and they voluntarily dropped it or whatever, they may have a lot of that information already from the prior proceedings. And if they do, whether the attorney asks for it or not, that's something that a client should logically share with the attorney, one would think, or at least let them know it's there so they don't have to reinvent the wheel or find out after the hearing, oh, I didn't know you had this, I didn't know you had that, this could have helped us, that type of thing. So there's really a mutual responsibility of both and need, I would say, for both the client and the attorney to work energetically together on prepping for your hearing. There's no guarantee it's going to change the result, but at least you're proceeding from a position of preparation and strength rather than just haphazardness and hoping things are going to work out without any structure, which is sometimes a difficult thing to accomplish. I'm sorry.
One of the suggestions that I have heard, I want to get your opinion on this, is since many judges in some jurisdictions handle a wide variety of cases from traffic court to criminal court, family court, and given that many of the divorce cases with domestic abuse can happen over a long period of time, the suggestion was for the attorney to write some type of quick summary that goes on top of the file for the judge so they can quickly get up to speed on the history of the legal proceedings, given they've got so much going on and don't necessarily have time to reread a whole file.
Well, each side can do that. Generally, in almost any case, not just domestic violence cases, if either side wants to submit what's commonly called a brief, which is kind of a summary of the case, basically a memorandum, perhaps giving a procedural history, case summary, perhaps citing to any cases or statutes. There are lots of things that could go into a brief or a legal memorandum, that type of thing.
Okay.
But keep in mind that when it's done by the attorneys, that's not evidence, nor is it testimony. That's just the attorneys arguing. That's the attorneys advocating and saying their piece. It's just like in a case, if you watch any case on any trial on TV, they're covering, you see this a lot with criminal trials. A a lot of attention is paid to the attorney's opening statements and their
Mhm.
summations, but neither the opening statement or the summations are testimony from anybody, and it's not evidence. It's the attorney's arguments is what that is. The brief that you're alluding to is basically a written form of the same thing. It's basically a position. You're taking a position. So the attorney, if wants to submit a summary of their summary of the history, that doesn't mean it's accurate. That doesn't mean it's testimonial. It doesn't mean it's under oath. It's just attorney argument. So it could be very helpful. When I was on the bench, it was sometimes very helpful to have a brief, a summary, but it was not evidentiary in general, and it could be challenged, and there's no guarantee that it's going to, have any impact or not.
Yeah.
I will tell you, though, that with generally in domestic violence, in the forms I was talking about before that they have from state to state, that one of the reasons they have those forms is to give the court the ability to kind of look over that form once it's complete and get at least a good snapshot as to what's going on here. So the section it may say in the complaint what the predicate act is and when it took place, what the alleged act is. If there might be a section like in New Jersey where I sat, they had a whole section that talked about to have prior incidents. So if someone is going down and filling out a domestic violence complaint, you want to your important prior incidents you want to have in there, so that for the exact reason you just said, Beverly, if the judge is reading it through, they have some idea that there is a prior history rather than leaving it blank. Some people wouldn't even fill that part in, even though there was a history, because it was too small or too narrow, or they were just focusing on the one incident. Then they come to court and they say they want to talk about all these other prior incidents, and the other side might object, saying, "Oh, you didn't give notice of that in the complaint." And sometimes the court may uphold that objection. So it's very important when you fill out a domestic violence complaint to make sure that you've got all the information there that you think is important for a court to know that's relevant to the blanks that are on that form. And I know that sometimes when people file a domestic violence complaint, it could be late at night. It could be at a very emotional time after a traumatic incident. And sometimes the officer, if a police officer's there, they're filling it out for you, or part of it, or someone's helping you. And you're not even taking the time to really read it through. You're just signing it because your head is somewhere else. But you're going to get a copy of that complaint. And it's really important to then, at least the following morning, read it through. And if you forgot anything, or if there's something you just completely overlooked, or you said something that was inaccurate because, emotionally you weren't, concentrating as much as, you were the next morning, you can ask to amend that complaint. You go down to the court and amend that complaint before the hearing takes place to add in whatever it is that you forgot. Because if you just wait till the day of the trial to do that and you bring that up, the other side might object. And the other side might say, or the other side's attorney might object and say, "Hey, this is a violation of what they call due process. We didn't have notice of this. We're not prepared for it." And the court might allow the amendment and adjourn the hearing. Or they might say, "Sorry, we're just sticking with what's in the complaint. It should have been amended, if ever, before the day of the actual trial." So, you always want to double check these things, and you can't just come at the court and say, "Well, I didn't take the time to read it," or "I didn't take the time to make sure it was correct." You can say that, but it might not be as, helpful as simply amending it beforehand so that you've got all your ducks in a row.
We've got just a few minutes left, but the big question is, how does an attorney really get to know more about how a judge rules or thinks about divorce involving domestic abuse?
Sure. Well, in general, and again, I don't want to lump all attorneys together, but in general, in family court practice, because family court is generally state law, it's usually not federal law, with some limited exceptions that we don't have to get into right now. But it tends to be usually the attorneys who focus in family court, and particularly domestic violence, tend to be, at least in my experience and observations, attorneys who regularly practice in family court in that particular jurisdiction, in that particular county. So by their very nature of their practice, they will have some familiarity with the limited domestic violence judges there may be in that courthouse. And they'll tend to know a little bit about what they can expect from that judge, what that judge expects from them in terms of evidence and things like that, or preparation. Now, that doesn't mean you can't hire an attorney from out of county or even out of state, as long as they have a license to practice in your particular jurisdiction, where the case is being held, to handle the case. You can. But if you're walking in anywhere without ever having any, even if you're the greatest attorney in the world, if you're walking into a courthouse and you know nothing about that judge and nothing about what's expected routinely, it might be dealing at a disadvantage, one might say, as opposed to having someone who is very familiar with that particular court and possibly that particular judge. So when I was on the bench, there were people who I would see them almost every day, like the same 20 or 30 attorneys. They were part of the family court bar, is what they called it, in the jurisdiction where I sat. They weren't the only attorneys coming in. I saw lots of people come in on domestic violence cases with attorneys who were out of county or who sometimes didn't have an attorney.
Yeah.
And you have to, and sometimes they did a great job. But they were kind of taking a risk because they knew nothing about me. And the way I handled domestic violence cases might be very different from the judge next door and how they handle it.
Maybe observe, yeah.
Right. So if there's an opportunity, even for an attorney, if they have time to, if you have any kind of important case going before a specific judge, to try to sit in and watch that judge a little bit, or at least ask some other attorneys who have practiced before that judge, what they tend to go with. There are lots of times there were people who, were before me, all the time. And the fact that they were before me all the time doesn't mean they could predict what I was going to do on a case, because I didn't even know what I was going to do on a case until I heard all the evidence. You don't pre-decide a case before you heard it. But in terms of what certain expectations were, procedures, things like that, they would know that. And they would know, if they'd been before me before, they would know that. And that could be very helpful. It wasn't held against somebody if they didn't know that because they had never been before me before. But there is an advantage, I think, in knowing and having been before that particular court and that particular judge before, just in terms of expectations, not the predicament result. I'm sorry.
Yeah, we've run out of time.
Yeah.
Again, it's always so great to have you. And again, we could talk for hours more, but we need to bring this to an end. Thank you for being with me today, Larry, on this episode. And thank you to the audience for listening. If you would like to listen again, you can find the link at divorcecoalition.com under the live show tab. The Divorce Coalition is a nonprofit organization created to change the re-traumatization of abuse victims and survivors by the divorce process and divorce professionals. We want to educate divorce professionals to create systematic change. For more information, go to divorcecoalition.com. You can also support us by making a tax-deductible donation at divorcecoalition.com/donate-now. Let's come together and champion a brighter future. Stay tuned next Thursday at 10 a.m. Eastern Time for another episode of Divorce Coalition Live. Until next time, remember, knowledge is power. Goodbye.
Take care.